Let's talk about something that catches thousands of well-meaning people completely by surprise. It's this hidden financial trap that starts with a simple act of love, helping out your aging parents, but it can end with some absolutely devastating penalties if they happen to have money overseas.
I know, that sounds a little dramatic, doesn't it? But seriously, could a simple legal paper, something you might have signed ages ago and totally forgotten about, actually put you on the hook for a massive financial liability? For a shocking number of people, the answer is yes.
So picture this. It's a super common story. Your parents are getting older and they want to make sure you can step in and help with bills or whatever's needed. So they give you power of attorney. It's the responsible, smart thing to do.
And you, wanting to respect their independence, you just file that document away. You haven't used it, you haven't touched their money, you haven't even called their bank. It's just sitting there in a drawer, just in case.
And right there, that's the trap. Because if that power of attorney gives you control over a foreign bank account, even an account with just a bit over $10,000, the U.S. government suddenly says you have a personal duty to report that account every single year, and not knowing is no excuse.
So how on earth is this possible? Well, it all boils down to a huge misunderstanding about how these rules work. We're talking about the FBAR system, and it plays by a completely different rulebook than the income tax system that we're all used to. You see, the duty to file gets triggered in two totally separate ways. First, you've got financial interest. That's easy. It means you own the account, like your parent does. But then there's this other thing, signature authority. That's all about control. And as the power of attorney holder, that's you. The key thing to get is that these are independent triggers. You can have one without the other, and either one means you have to file. And here's the official jargon, but in plain English, it just means you have the ability to tell the bank what to do with the money. Can you legally call them up and say, move these funds? If the answer is yes, you have signature authority. That's it.
Now, this is the single most important point, the one that gets everybody. It does not matter if that power of attorney is collecting dust in a drawer. It doesn't matter if you've never even heard of the foreign bank. The moment that piece of paper became legally effective, you got the authority. And just having that authority is what kicks off your duty to file.
And just when you think you've got it figured out, it gets even more complicated. Because this isn't just about you filing. The rules often demand that the very same bank account gets reported by two different people.
You know, for married couples, there's a nice common sense shortcut. If they have a joint account, they can usually just file one FBAR for both of them. But here's the kicker. That helpful exception does not apply to a parent and a child.
So this means you have two separate filing jobs for the exact same account. Your parent, the owner, has to file their FBAR saying they have a financial interest. At the same time, you, the child with the power of attorney, have to file your very own separate FBAR reporting your signature authority. If you don't file yours, it's a violation, even if your parent did theirs perfectly.
Okay, so what really happens if you mess this up? This is where the consequences get, well, they get really serious. The penalties all depend on what the IRS thinks your mindset was.
First up, let's talk about a non-willful mistake. This is for an honest error. You just didn't know the rule. The maximum civil penalty is over $16,000. And get this, that's not a one-time fine. That can be applied for every single year you fail to file.
But if they decide your failure was willful, the penalty just explodes. It's the greater of over $165,000 or half the money in the account. Just think about that for a second. If you have POA over your mom's $400,000 account, you could face a personal penalty of $200,000 for an account you don't even own a penny.
So what's the difference? Well, non-willful is basically an oops, it's a mistake. Willful, though, that's not just about intentionally hiding money. It also includes something called reckless disregard, which means you had reasons to ask about the rules but chose to look the other way.
And that leads to this legal idea of willful blindness. Basically, the courts have said you can't just stick your head in the sand. If you sign a tax return that literally asks about foreign accounts, you have a duty to find out what that means. Deliberately avoiding the question can be treated as willful, and that's what triggers those life-altering penalties.
All right, so to stay out of this mess, you have to understand a few really important details that trip up a lot of people.
One of the biggest points of confusion is the difference between the FBAR and this other form called FATCA Form 8938. Now, the FATCA form is usually only for people who actually own the asset. So someone with a POA might correctly realize they don't need to file that form, and then they make the fatal assumption they don't need to file an FBAR either. But they're wrong, because the FBAR has that whole separate signature authority trigger. The type of power of attorney you have also makes a huge difference. A standard, durable POA is usually effective the second it's signed. That means your filing clock starts ticking right away. But a springing POA is different. It only springs into effect after a specific event happens, like a doctor certifying your parent is incapacitated. This can delay your filing duty, but you have to be ready to go the moment it's triggered.
And it's not just about filing either. The law also says you have to keep records for every account you report for 5 years. We're talking account numbers, the bank's name, the highest balance it had during the year, the whole shebang.
Okay, after hearing all of that, you might be feeling a little stressed. But here's the good news. If you've just realized you might have made a mistake in the past, there are clear ways to get back on track. And there are really smart ways to keep this problem from ever happening in the first place.
For most folks caught in this trap, the ones who genuinely just didn't know, there's something called the Delinquent FBAR submission procedures. This is the golden path. As long as you've reported all your income correctly and just missed these forms, you can file the back reports, write up an explanation, and generally the IRS won't hit you with any penalties. It's a huge relief.
And even better, here's how to avoid the trap completely. When you're drafting a power of attorney, you can specifically write in that it excludes authority over foreign accounts. Using one of those springing POAs is another great move. And for all you tax pros out there, always ask clients not just if they own foreign accounts, but if they have signature authority over anybody else's.
So we end right back where we started. That piece of paper gives you incredible authority to help someone you love. But with that power comes a whole set of responsibilities most people never see coming. Knowing what those are is the absolute key to protecting your family and protecting yourself. Thanks for tuning in.